Welcome back to the Deep Dive, where we unpack complex topics to make you well-informed. Today we're diving into a really crucial piece of legislation. It impacts a very specific, very important group in our society, those planning for or already in retirement. Imagine trying to make a huge life decision, like where you'll spend your later years, and you're faced with these, dense legal documents. That's exactly why we're here today. We're going to take a consolidated act, sort of peel back its layers, and look at its purpose, its key protections, and, well, what it all means for you, whether you're just curious or maybe a law student looking into it.
Indeed. Our focus today is the Housing Development Schemes for Retired Persons Act. That's Act 65 of 1988. Now, this act, it officially kicked off July 1st, 1989, and it's seen updates since then to keep it relevant. It plays a vital protective role. Its core purpose, stated right in the text, is to regulate the alienation of certain interests in housing development schemes for retired persons and to provide for matters connected therewith. Now, alienation, just to clarify, in legal speak, it simply means selling or transfer, basically giving up a right or interest in property. So fundamentally, this act is designed to bring, let's say, clarity and security to transactions that honestly could otherwise be incredibly complex and potentially risky for people making these big life changes.
Okay, let's unpack that a bit for everyone. First off, when the act says retired persons, who exactly are we talking about? What's the definition here? And what kind of housing interest or scheme falls under its protection?
Right. Well, the act is quite forward-thinking on who it covers. A retired person is defined simply as someone who is 50 years of age or older.
50. So quite early then.
Exactly. The protection kicks in much earlier than what many might think of as traditional retirement age. It covers that whole planning phase, too. And when we talk about housing development schemes, we're looking at basically any arrangement where housing rights are sold for occupation. It's a broad definition, covers things like share blocks, sectional titles, but it's important to note it specifically excludes property time-sharing schemes.
Okay, no timeshares. Got it.
And a housing interest. Well, this isn't always about outright owning the land. It means any right to claim transfer of the land, or, and this is crucial, simply the right to use or occupy that land. That distinction is fundamental because, as we'll see, the Act is really focused on securing your right to live there, sometimes regardless of the type of ownership.
That's a really important point, securing the right to live there. That can feel quite different from owning it outright, can't it? So is this act like a standalone rulebook, or does it, connect with other existing laws?
Oh, it definitely doesn't exist in a vacuum. No, it's intricately woven into the existing legal fabric. For instance, it borrows definitions, principles from other key property laws, like the ones governing sectional titles, and it makes sure it's consistent with social welfare laws, like the Aged Persons Act, especially when defining who might need, say, specialized care within a scheme.
Right.
It also leans heavily on established land registration rules. So this approach, it ensures continuity. It leverages existing legal protections rather than trying to reinvent the wheel,
Yeah, that makes sense. Build on what's already solid.
Exactly. It means the Act benefits from decades of legal thinking and precedent.
Okay, so given how significant these transactions are, what are the absolute must-haves, the non-negotiables for a contract to be legally sound and really to genuinely protect a retired person?
Well, this is where the Act lays down some critical safeguards right from the start. Section 2, it deals with formalities in respect of contracts. And it states quite unequivocally that no sale or transfer of a housing interest will be legally binding unless it's contained in a contract signed by the parties, or their authorized agents, acting with written authority, of course.
So everything in writing, signed, no wiggle room there.
Precisely. That's a foundational protection. No informal chats, no verbal agreements for something this big. It has to be written down for clarity, for accountability, helps prevent disputes later on.
That's a clear baseline for sure, but I imagine for such a crucial purchase, especially involving developers, the Act demands a lot more specific information, right? What kind of details must be in these contracts?
You're absolutely right. And what's fascinating here is just how incredibly thorough Section 4 gets. This section outlines the contents of contract, particularly when the seller is a developer. The Act really tries to anticipate every single piece of information a retired person would need to make a properly informed decision. It's quite impressive.
Like what, for example?
Okay, so the contract must include, among many other things, a clear description of the legal basis for the housing interest. Is it full ownership, a lease, or that unique right of occupation we touched on?
Right. Clarity on what you're actually getting.
Exactly. Also, the duration and any limitations on that interest, so you know exactly how long your rights last and if there are any restrictions. A statement on whether the interest can be registered and, this is vital, if the property's main title deed has been endorsed. That's a key requirement we'll definitely circle back to.
Okay, endorsement. Got it.
Then extensive details about the property itself, earth numbers, unit numbers, size, location, the specifics. And if the property has a mortgage bond on it, this is crucial, the contract has to disclose the lender's details and the outstanding balance.
Wow.
And, get this, if you're buying a right of occupation, it must state how much of your payment will actually go towards reducing that mortgage. That's a key financial safeguard.
That is important. Protects your investment.
Definitely. Then, clear info on the total cost of the consideration, whether it's purchase price, rent, whatever, including interest rates, how installments are paid, total transparency on money. Also, a statement detailing the location, nature, and extent of any facilities or services promised. Things like clubhouses, care facilities.
Including if they cater for residents needing assistance.
Yes, explicitly. And the date by which these facilities will actually be ready for use. No vague promises. And finally, some financial forecasting. An estimate of expenditure for managing the scheme for 3 years, and an estimate of the likely levy for 2 years, plus how it's calculated.
So you have an idea of ongoing costs.
Precisely. And one last practical point, you, the purchaser, have the absolute right to choose the official language the contract is drawn up in.
Wow, that is an exhaustive list of disclosures. It really sounds like the Act is bending over backwards to prevent any nasty surprises. Mandating total transparency. What about clauses that might, sneakily try to strip away a retired person's rights? Or unfairly favor the developer? Does the Act block those?
Absolutely. The Act is very aware of potential power imbalances in these deals. Section 4, subsection 5, explicitly declares several types of provisions null and void if they appear in a contract. These are direct protections against clauses that might subtly, or not so subtly, disadvantage the purchaser.
Such as?
For example, clauses that try to make the seller's agent your agent as well. That's a clear conflict of interest, right?
Definitely.
Or clauses trying to exempt the seller from liability for what their own agent does or says. Or limiting the seller's basic duty to protect you from eviction. That's fundamental. Or trying to force you to agree up front to the seller just handing over their responsibilities to some unknown third party later on.
No blank checks there.
Exactly. And the Act also addresses something called a recoup stipulation. It's a fancy legal term for a penalty clause, basically, where if you cancel, you might forfeit money. The Act makes sure any such clause is subject to broader fairness laws, the Conventional Penalties Act, preventing excessive or arbitrary financial punishment.
Okay, so real teeth there against unfair clauses.
Yeah.
Now, you mentioned this right of occupation a couple of times. This sounds like where it gets particularly interesting, especially with the amendments. What exactly is this right? And why is it considered so powerful for retired persons?
Yes, the right of occupation. It's a really distinct and I'd say often quite revolutionary type of housing interest. It was specifically designed for a certain need. It typically involves you paying a sum, maybe as a loan, maybe in installments. Sometimes it's even refundable to some extent. This might be on top of, or sometimes even instead of, a regular levy. But the crucial part, the real power, is that this right grants you the ability to occupy a part of the housing scheme for your entire lifetime, or the lifetime of another person named in the contract.
For life.
For life. But significantly, it does this without giving you traditional ownership of the land or the unit.
So it's like a super secure lifelong lease, almost.
You could think of it that way, but it's actually stronger in some respects. It's about securing your spot, your home in that community for life without the burdens and complexities of full property ownership. It's often a perfect fit for retirees seeking stability, community, maybe shedding some responsibilities. And that's exactly what the legislature wanted to protect here.
Okay, a very specific long-term right to reside. But if it's not traditional ownership, how on earth does the Act protect such a unique right? Especially, if the developer runs into financial trouble. That sounds like a potential risk.
That's an excellent question, and honestly, it's where the 1990 amendments really showed their strength. They transformed this right of occupation into an incredibly secure interest, really robust.
How so?
Well, first, Section 4A. It states that if you hold a right of occupation, you essentially have the same rights as someone with a properly registered lease. That gives it legal weight. But here's the kicker. These rights rank in priority over any other right, whether that other right is registered or not, and regardless of when it was registered.
Wait. Any other right? even a bank's mortgage.
Even a bank's mortgage in certain crucial situations we'll get to. This means your right of occupation, once it's established correctly, becomes incredibly secure against competing claims. This was truly groundbreaking. Historically, a bank's mortgage was almost always king. Before this amendment, if a developer went bankrupt, residents holding these rights could face eviction, even after paying huge sums.
Nightmare scenario.
Absolutely. This act fundamentally shifts that risk. It prioritizes the residents' security, their home, sometimes even above the bank's claim. It reflects a deep societal commitment, I think, to protecting older citizens. Then there's Section 4B. This adds another layer, protecting the whole scheme's integrity. The land in the scheme cannot be sold free from these rights of occupation unless at least 75% of the holders agree in writing.
75%. That's a high bar.
A very high bar. And here's the critical financial safety net. If the land is sold with that consent, the holders of these rights get preferential claims on the money from the sale. Their claims rank ahead of any mortgagee's claim, up to the amount they originally paid for their right of occupation.
Wow, so they get first dibs on the proceeds even before the bank.
Up to the value of their investment, yes. And any attempt to sell the land without getting that 75% consent is simply null and void. Doesn't count. And finally, Section 4C. This puts a crucial obligation squarely on the developer. For schemes started after the 1990 changes, they cannot sell a right of occupation unless the property's main title deed has been formally endorsed by the Registrar of Deeds. This endorsement, which needs the consent of the owner and any existing mortgage holder, publicly declares, this land is subject to a housing development scheme for retired persons.
Ah, so it's like a permanent, visible stamp on the property's official record.
Exactly. It serves as a clear warning flag to anyone looking at the title potential buyers, lenders, that these special protected rights exist. And failing to get this endorsement before selling a right of occupation, that's a serious offense. We're talking fines up to $20,000 or up to 5 years in prison or potentially both.
Okay, so serious consequences. That endorsement really locks in the protection publicly. That's huge.
It really is. It makes these rights incredibly difficult to ignore or bypass. A powerful shield.
Okay, so beyond the contract itself and this very strong right of occupation, let's talk practicalities.
Wow.
What if you've paid a lot of money, but the developer hasn't finished building or the promised facilities aren't there? How does the act make sure your money is safe and you actually get what you paid for?
Right, the what if things go wrong during development question. Section 6 tackles this head-on with restrictions on receipt of consideration. It's very clear. A developer cannot legally receive any payment from a purchaser unless specific, quite stringent conditions are met.
Okay, what are those conditions?
Firstly, an independent architect or quantity surveyor must issue a formal certificate. This certificate needs to state that the scheme is substantially built according to the approved plans, and it's complete enough for the housing interest your unit, essentially to be properly used.
So independent verification of progress.
Yes, independent verification of progress and basic usability. Secondly, copies of this certificate, along with the contract itself, must be given to you, the purchaser. Full documentation. And thirdly, specifically if your interest is a right of occupation, a qualified attorney must certify that the main title deed has been properly endorsed as required by that Section 4C we just discussed.
So all the legal protections for that right must be firmly in place before they can take your main payment.
Precisely. You can't just hand over your life savings until there's independent proof of sufficient construction and confirmation that the key legal safeguards, like the title deed endorsement, are done.
But what if, the worst happens? The developer goes bankrupt before those conditions are met. That's still a massive fear for people.
A very valid fear. And the Act anticipates this potential disaster. Section 6, subsection 3, allows for developers to receive money earlier only under two very specific safeguarded exceptions. 1, the money can be paid into a trust account held by a qualified attorney or an estate agent. This account holds the money securely, ring-fenced, only to be released to the developer once all those conditions in Section 6.1, the certificate, the endorsement, are met.
So it's held independently.
Yes. Or option 2, you, the purchaser, must be given an irrevocable and unconditional guarantee from a registered bank or insurer. This guarantee essentially promises to pay the full amount back to you if the developer fails to meet those conditions.
Like an insurance policy on your deposit.
Effectively, yes. And then Section 6, subsection 4 drives the point home. If the developer becomes insolvent before those conditions are met, any money held in that trust account or covered by that guarantee immediately becomes payable directly to you, the purchaser.
Ah, so you get your money back even if they go bust.
That's the crucial protection. It shifts the financial risk of the developer failing before completion away from the retired person and onto the developer or their guarantors, a vital safety net.
That really is a powerful protection against losing your investment. What kind of consequences do developers face if they don't follow these rules about receiving payment?
Well, these aren't just suggestions. Ignoring these rules, trying to take money before the conditions are met without using the trust account or guarantee, that's a criminal offense. The penalties mirror those for failing to endorse the title deed under Section 4C, potentially a hefty fine up to R20,000, or imprisonment for up to 5 years, or even both.
So, serious deterrence.
The law clearly views protecting purchaser funds and ensuring quality as extremely important.
And quickly, what about those facilities we mentioned earlier, the ones for residents needing assistance, maybe like a frail care unit within a village? How are those regulated?
Good point. Section 5 clarifies that if any facility within the scheme listed in your contract, remember, is primarily for the care of debilitated persons, as the Act terms it, then that facility is automatically deemed to be a home for the aged under the Aged Persons Act of 1967. This means specific sections of that act, which deal with standards, licensing, inspections, and general oversight for care homes, automatically apply to that part of the retirement village.
So it connects a housing scheme to broader social care regulations.
Yeah.
Ensures proper standard.
Exactly. It ensures that if specialized care is offered, it meets the established legal standards for that type of care.
Okay, shifting gears slightly. One of the big attractions of retirement living is often the community itself, right? People choose these places for a specific atmosphere, often wanting to live among peers. How does the Act help maintain the intended character of these schemes?
That's a really important aspect, the community feel. And Section 7, titled Limitation of Occupation, directly addresses this. It's quite a powerful tool for maintaining the scheme's purpose. It states that once a housing interest has been transferred or properly vested, no person other than a retired person, remember, 50 plus, or the spouse of a retired person may occupy the property that interest relates to.
No one else at all.
Well, there's one exception. Unless they get the written consent of all other holders of housing interests in that specific scheme.
All of them. That sounds practically impossible in most schemes.
It's designed to be a very high threshold. The default is only retired persons and their spouses. This ensures you can't just have, say, younger families moving in and fundamentally changing the nature of the community that people specifically bought into.
So it really protects the integrity of that retirement environment.
Precisely. It ensures the scheme primarily serves its intended demographic, preserving the lifestyle and community people signed up for, and violating this occupation limit, that's also an offense.
Penalties for that, too.
Yes, though less severe than the financial ones. A fine up to R1,000 or imprisonment for up to 6 months, or both. But it sends a clear signal about the importance placed on the community's composition.
Okay. So we've covered contracts, rights, finances, community. But despite all these protections, sometimes things still go wrong, don't they? What happens if a contract is maybe found to be void later, or if the developer just doesn't deliver on their promises? What recourse does a retired person have then?
You're right. Even with strong rules, disputes happen. The Act provides significant avenues for relief. Section 8 deals with the consequences of contracts which are void or are canceled. If a contract is found to have no legal force, maybe it wasn't signed properly as Section 2 demands, or if it gets legally canceled, the general rule is both parties can recover what they've already performed or paid, give back what you got. But crucially, if the seller is a developer, the protections for the purchaser go further. You, the purchaser, can also recover interest on any payments you made. And reasonable compensation for necessary expenses you incurred, maybe keeping the property maintained, or for improvements you made that increased its value, provided you had consent.
So you're not out of pocket for those extras.
Correct. Conversely, the developer can recover reasonable compensation for your occupation or use of the property if you live there, and for any damage you might have caused. It aims for fairness. But there's an important exception in Section 8 too. If a contract was initially invalid just because it didn't meet the written formality requirement of Section 2.1, but later you, the purchaser, have paid everything in full and the property or housing interest has actually been transferred to you, then the contract becomes valid from the very beginning. The legal term is valid ab initio. This practical rule prevents purely technical flaws from undoing a transaction that's essentially been fully completed by both sides in good faith.
Ah, okay. A common sense fix for completed deals. But what if the issue isn't that the contract is totally void, but maybe it's missing some required info, or the developer just fails to meet some other obligation. Is there still a way to get things sorted through the courts?
Absolutely. That's where Section 9 comes in, titled Relief That Court May Grant in Respect of Contracts. This is a really empowering section for purchasers. It says if a contract doesn't substantially comply with those requirements we talked about, like the language choice or the detailed content rules in Section 4, or if a seller simply defaults on their obligations or breaks other regulations, and you, the purchaser, can show you've actually suffered prejudice because of it, then a court can step in.
What can the court do?
The court has quite broad discretion. It can reduce the interest rate you have to pay the seller if interest is applicable. It can order rectification of the contract, basically fix the errors to make it comply. It can even declare the contract void from the beginning if the non-compliance is severe enough.
So a range of options.
Yes, or it can grant any other alternative relief it thinks is fair and just in the circumstances. And significantly, the Act states that a magistrate's court has jurisdiction here, regardless of the value of the housing interest.
That's important, makes it more accessible. Less costly than higher courts.
Much more accessible for individuals, exactly. And you generally have a 3-year window from the date you sign the contract to bring these kinds of proceedings. That gives a reasonable time to identify problems and take action.
What an incredible deep dive into this act. From the specific definition of a retired person starting at 50 to the mandatory contract contents, those really powerful priority rights for rights of occupation, and serious penalties for noncompliance. It's clear this legislation provides a really robust framework. It aims to protect older individuals when they're making potentially one of the biggest decisions of their lives, ensuring they're informed and financially secure.
Absolutely. I think this act is a clear testament to the need for and the effectiveness of specialized legal protections for specific groups in particular markets. Retirement housing is unique. It champions transparency, it bolsters financial security, and it helps preserve the intended character of these communities, which is so vital for residents' peace of mind and well-being. For anyone out there considering buying into such a scheme, understanding these provisions isn't just, a legal nicety. It's absolutely essential due diligence for your long-term security. It's a powerful shield.
So wrapping up, what does this all mean for you listening? How do these very specific protections, especially elevating rights of occupation, sometimes even above mortgages, reflect our broader societal values about caring for our elders and ensuring their financial security in later life? And perhaps thinking bigger, what might the principles embedded in this act suggest about how we could, or maybe should, legislate protections for other vulnerable groups navigating today's complex housing market? Definitely something to ponder on your own deep dive.